Bonjour, bonjour à toutes et à tous. Good morning. Je suis ravi de vous accueillir ce matin en si grand nombre pour cet événement numérique. I'm delighted to welcome you today for this online event. For those who don't know me, my name is Florian Martin Barito. I'm the director of the Center for Law, Technology and Society at the University of Ottawa, where I hold the University Research Chair in Technology and Society, and I am a full professor in the Faculty of Law, Common Law section. Today, I'm delighted to welcome you for this online conversation with a friend of ours, Professor Ignacio Cofoni, around his new textbook, Canadian Privacy Law Cases and Comparative Materials, that is already a success, and that explore like all legal frameworks are evolving to address the challenges of privacy in digital age and will help academics in Canada to be equipped to teach this very important topic for Canadians. For those who don't know him, Dr. Ignacio Cofoni is a professor of law and regulation of AI at the University of Oxford. He was previously a professor in the McGill Faculty of Law and was holding a Canada Research Chair. And so he moved across the pond and now is appointed in the Faculty of Law, but also at the Institute for Ethics in AI in the Department of Philosophy at Oxford. And today we'll be joined by one of Canada's top privacy thought leaders, or actually another one of Canada's top privacy thought leaders, Dr. Tirzas Casa, who is the Canada Research Chair in Information Law and Policy, a faculty member of the Center for Law, Technology and Society, and a full professor in the Faculty of Law Common Law section at the University of Ottawa. And she will share some of her early thoughts on this new textbook. And so without further ado, I will hand it over to, I think, Dr. Scassa to kick off the conversation. Thank you to both Dr. Cofoni and Dr. Casa to be with us today and for all of you to be in attendance. Thank you.
Thanks so much, Florian. It's such a real pleasure to be able to have this, to sit down and have this conversation with Ignacio Cofoni about his new book. Before we get started, I'm just going to say, to give a brief land acknowledgement. This webinar, the CLTS is, and the University of Ottawa are situated in Ottawa. And so we pay respect to the Algonquin people who are the traditional guardians of this land. We acknowledge their longstanding relationship with this territory, which remains unceded. We pay respect to all Indigenous peoples in this region from all nations across Canada who call Ottawa home. We acknowledge the traditional knowledge keepers, both young and old, and we honor their courageous leaders, past, present, and future. So, welcome, Ignacio. Even if you are coming to us remotely from the UK, welcome to the webinar. I'm going to jump right in with questions and ask you, what motivated you to create a casebook for Canadian privacy law?
Perfect. Thank you. And well, first of all, thank you so much, Teresa, for doing this. And thank you to Florian and Lisa too for hosting this session. I'm really excited to be here to talk with well, everyone in the webinar, but particularly also with you about this. What motivated me to create a casebook for Canadian privacy law? So I started building the material that they turned into this casebook about 7 or 8 years ago, where I was at McGill, out of somewhat a frustration, which is that there was no Canadian privacy law casebook that would cover all of the areas. So instructors across the country assembled ad hoc horsebacks every year, drawing partly from American casebooks that assume a constitutional and regulatory structure that does not map onto Canada, partly from cases that they individually had to determine in CanLII were most relevant, assigning experts for treatises that cover statutory interpretation, but not necessarily the conceptual foundations, and then papers that covered those conceptual foundations. So what I wanted when I was teaching this course throughout the years, and when I hoped to put together with this casebook, is a single resource that treats privacy law as one legal subject. So the tort of intrusion upon seclusion, PIPEDA's requirements, Section 8 of the Charter, while they're different institutional responses, they are, I think, institutional responses to the shared problem of the conditions under which someone can acquire, use, or share information about you. And I try to make in the casebook a treatment that would help those areas learn from each other.
Right. Yeah, and I certainly agree with you about the gap and the struggle to pull something together. So when you decided to produce a casebook, you obviously had students in mind and professors as well. But what other audience do you think this book would serve?
Yeah, so I think that's right, that the primary audience that I had in mind were students. Not only my students at McGill, but students from across Canada who have to take this course from anyone. And the decisions of this casebook were mostly pedagogical decisions of what sequence to present the material in for someone who's approaching privacy law for the first time, when to introduce different complexities, how to frame different questions that would help instructors push students beyond summary of different materials towards analysis and learning to think about it. But beyond that primary audience, you asked me about other audiences than that. I think there are two audiences that this book could also reach. So one is practitioners. Practitioners in Canada are extremely sophisticated in privacy law. That said, most of them, not all of them, particularly not the younger ones, but most of them that lead these practices came to privacy law from other areas like employment law, IP, or commercial litigation. So they learn privacy on the job, and they might benefit from a systematic overview about how these different regimes interact, because they're probably primarily working on PIPEDA and provincial law. And so this case provides that overview and has some comparative materials that would also help them anticipate where Canadian privacy law might be heading. And the second audience that I think this might be helpful to, besides students and besides practitioners, is policymakers and regulators, particularly because Canada is right now in the middle of a large conversation since 2019 about privacy law reform that has been going on, unfortunately, without yet producing new legislation, as you know very well. And so the casebook does map the regulatory landscape in a way that I think makes it easier to see the gaps and to see where there's most important opportunities for improvement of the existing legal framework that might help people that are involved in the discussion.
Okay. Yeah, thank you for that. And of course, I totally agree with you about the privacy law reform conversation. Lots of time to get into that one. I just want to say before we go any further, just to our audience, that Ignacio and I are having a conversation about the book, and I'll be asking him lots of questions, but I invite your questions as well, and so does he. There's a Q&A box in this Zoom application, and so if you have questions as we go along, feel free to add them to the Q&A. Okay, so this is a huge area of law. It really is, and it keeps getting bigger. Can you tell us a little bit about how you went about choosing the content and the structure for your book?
Yeah, I appreciate the note that it's a huge area of law, because it's what I kept telling the publisher that was extremely understanding on the number of pages that one needed to cover all of it, and very supportive in all these decisions. So I'm also very grateful to Emma for all the help with the process. So how did I choose the content and structure? Well, I think the choices of content and structure mostly derive from the organizing thought that I briefly mentioned earlier, on the fact that privacy law is one subject and not three. So the book is organized in 4 parts. One is privacy torts for digital harms. One is statutory privacy in the information economy. One is privacy and law enforcement. And the fourth one is on special topics. And the idea is to connect these different areas of privacy law, showing how they share doctrinal similarities and showing how ideas from one, like reasonable expectation, travels to the other ones in ways that is productive, and in ways that it's productive to see them together. ideas that students encounter in one part of the book are then continued on the other parts of the book across privacy, torts, statutory privacy, and Section 8. And I think a secondary organizing idea was that privacy law in Canada is best understood when not seen in isolation. So when seen not only in the context of what different provinces are doing, but also in the context of what different countries are doing. Not only because of the cross-jurisdictional nature of data flows, but also because of how Canadian law is influenced by US privacy law and EU data protection law in a number of ways. So I made sure throughout the book to incorporate these notions of US law and EU law to understand Canadian law in better in context. This is both because I think Canadian law as is better understood in that context, but also because if finally these legislative changes that we hope for arrive, understanding Canadian law in that context helps us see where it might be going, and it helps us better understand those changes that might arrive.
Yeah, and in fact, I noticed, and I was going to draw attention to this at some point, that in the title of your book, so usually these case books have a kind of a standard format, and there's the broad subject area, in this case, Canadian privacy law, and then it usually says underneath cases, notes, and materials. And I noticed that yours says cases and comparative materials. So you're really highlighting this comparative dimension of your book, aren't you?
I think it's an important aspect for privacy law. It's not just anecdotal comparisons like we might have in other areas of law where it's interesting to see what other systems are doing. But I think in the case of Canadian privacy law, not all aspects of them, but many aspects of US privacy law and EU data protection law directly influence what privacy law looks like, and how privacy law is applied and where it might go. So I did think that for this particular kind of casebook, incorporating the comparisons is quite important.
Yeah. Okay. So here's an easy question. What do you think are the broad privacy law themes that it's crucial to understand?
Oh, yeah, that is an easy question. In a non-exhaustive list, let me think of a couple. I think one crucial aspect in privacy law is understanding the relationship between the rules of privacy law and the power that is enabled by holding and processing information about people. That's one thing that my work in general tries to highlight across this casebook and also other books and articles. The idea that privacy law is about regulating the distribution of informational power and about what kind of informational power we enable and what kind of informational power we control. I think that framing has significant consequence about how we see the different doctrinal tools, because lots of rules that might seem procedural or with aims that sometimes escape people that might read a privacy statute then become understandable ones. People see them through that framework. A second theme that I think is important to understand in privacy law is the limits of the model that PIPEDA has that worked or ostensibly worked quite well 25 years ago when it was designed, but don't work so well with the current state of technology. So PIPEDA is built on consent as a primary basis for data processing, more than the statutes that it's modeled after from the EU. And there are some ways that PIPEDA moderates this dependent on consent, but PIPEDA is still more dependent on consent than other statutes around the world. And that model was already strained before AI and is certainly strained after AI in a way that I think acknowledging is helpful when thinking about productive reforms. And I think the third thing that I would think is important to think about in privacy law right now is the importance of the enforcement architecture, both in terms of the powers that the OPC has and in terms of the abilities that we give people to go to court for privacy injuries. Having rights on paper, well desirable, doesn't matter very much if then authorities don't have the power to bring them to life or the resources to bring them to life. And we put lots of barriers for people to go to court with those rights. And so this informs not only particular debates on reform of whether the OPC should have enforcing making power and particular debates on Canadian procedural law, but I think alters how we want to shape the content of privacy law, because that content is best shaped in a way that can be enforced publicly and privately.
And that's such an interesting point. I know you've written about privacy class actions before as well, and those have taken up a lot of space in the Canadian legal scene of late, and probably in large part or due in part to the fact that there's not a lot of enforcement power in PIPEDA, and so they tend to carry a bit of heft. And so do you see an interesting dynamic between the weaknesses in PIPEDA and the rise of the privacy class action in Canada?
Yes, I think there could be an even more interesting dynamic, but there is somewhat of an interesting dynamic. PIPEDA is quite limiting in how it allows private rights of action because it requires an investigation by the OPC before people bring an action to court. Requiring an investigation from the OPC before people bring an action to court is something that might work if we had an enforcer with infinite resources that can investigate everything, even if they don't have enforcement powers, because then the enforcer could avoid some of the litigation caused by doing that investigation, and then you could bring the report and take it to court. But in a world where privacy touches on everything and the OPC doesn't have as many resources as they could have to do all these investigations, requiring investigations from the OPC produces a significant bottleneck for people bringing privacy class actions. Now, those privacy class actions, and this is part of the interesting dynamic that you mentioned, can be more promising on provincial statutes, particularly in BC, but also on other provinces. So it is interesting how, while privacy class actions have been on the rise across the world, in Canada, we see a marked difference in how they're increasingly popular, increasingly important to try to compensate for this lack of enforcement powers that the OPC has, despite many attempts at reform.
Yeah. So your book starts with privacy torts, including online harms. Why do you think that's an important starting point for learning or thinking about privacy?
Oh, yeah. So that was mostly a pedagogical decision. And that's because I think it is helpful that before students learn the mechanisms of PIPEDA and all the consent requirements, that they understand what is at stake when privacy is violated, that they understand what is the interest that privacy law as a coherent body of law is trying to protect. And tort cases do this relatively well because they involve identifiable plaintiffs, they involve specific injuries, and they often involve judicial reasoning about what makes something wrongful. This is particularly the case of tort cases that created the different privacy torts, like Jones in Ontario, where the court had to explain why it is that we are protecting this. And I think coming with all that knowledge into PIPEDA compliance is helpful because then it's good to see what it is doing. But there's also, I think, an analytical reason that goes beyond the pedagogical reasons, which is that privacy torts, exactly because of this harm identification, reveals something about the nature of privacy that sometimes the way that we practice statutory compliance obscures a little bit, which is that privacy law is not a mechanism just for regulating data flows in ways that doesn't protect any social value, but rather privacy law is about recognizing particular injuries to individual and group interests that involve processing, collecting, and disclosing personal information. And which, if one starts with PIPEDA and one never sees torts and one never sees Section 8, it is easy to forget about that and to think about privacy exclusively in terms of compliance obligations and not in terms of interests and rights. So I think analytically coming with some knowledge of privacy torts is helpful.
Mm-hmm. Yeah. You address the impact of AI on privacy in the book, particularly in relation to anonymity, as well as certain privacy impactful uses such as inferences and things like algorithmic pricing. But you don't have a separate AI and privacy section. So how do you think about the relationship between privacy and AI technologies?
So I think, and the reason for which there's no separate chapter on AI, even though the first few times that I taught privacy law, I did have a separate unit on privacy and AI that I then dissolved. The reason for which I didn't put a separate chapter on this, after thinking about it for the longest time, is that I don't think AI creates a separate category of privacy problems. I think AI intensifies and transforms lots of pre-existing privacy problems that our legal framework may or may not be well equipped to handle. Most of the times, it is not very well equipped to handle. And so having one unit on privacy and AI, I think, risks suggesting that AI is some sort of add-on where we can have one or two amendments to the statute and solve it, as opposed to something that runs throughout Canadian privacy law. And I think the two things that you mentioned are the perfect examples of this. Anonymity is a great example of this because AI changes the way that we should think about anonymization and the identification on which PIPEDA relies and on which reforms also rely. But it doesn't create the problem. The limits of anonymity existed before as well. And the idea of AI inferences puts pressure on the idea of consent because in a world of inferences where we cannot predict reasonably what will be guessed about us based on the information that we disclosed, we cannot rely on people saying yes or no to particular privacy decisions because they don't have a full picture about what happens after. So while AI puts pressure on that because it increases the problem, AI didn't create that problem. There was pressure on consent with big data analytics and even before big data analytics, way before AI. And I think those are two instantiations of a larger problem. AI puts pressure on lots of things. And so touching on AI throughout the book, I thought was more productive than bracketing and concentrating the conversation in one particular chapter.
Okay. I just as an aside here, I wonder what you think about the location of the right to an explanation in privacy law.
That's a good question, and I don't think I have a good answer to it.
Okay.
I would like to, first of all, okay, I want your answer to this after I give you mine, which is I'm of two minds on this. On the one hand, I don't think, strictly speaking, the right to an explanation belongs to the idea of privacy law because privacy law is about how one could, one should collect, process, and disclose information about others. And the right to an explanation is more a guarantee for algorithmic or automated decision-making in ways that protects from lots of other things. But then on the other hand, I also see privacy law protecting a varied set of interests and not only the privacy interest. And we see this in privacy torts as well. Privacy law protects people's privacy, but it also protects people's reputation. Some privacy rules protect people from being discriminated. So if there is a statutory division, like the EU seems to have taken with the AI Act and the GDPR, and like Canada seems to have attempted with the last reform effort that didn't succeed, where all of the individual rights are on the privacy statute and all the systemic public enforcement aspect are on the AI statute, then while the right to an explanation doesn't protect a privacy interest because the mechanics of it work through when someone processes your personal information to make a decision about you, you have this right, then I wouldn't see significant problems in including it there. I don't know if you agree with me or you have a different view.
Yeah, no, like you, I struggle with it a little bit. Because I think the rationale for fitting it within privacy legislation is this idea that it's using your personal information to make decisions about you, although it may be using all kinds of, with automated decision making, there may be all kinds of other information that is involved as well. And then the rights that are framed around it tend to be access and correction type rights, as opposed to substantive procedural rights where you're confronting automated decision making. And it always worries me that that a government might think it's done its bit for automated decision-making by locating it in privacy legislation with that privacy slant and not dealing with the more substantive elements. So I do struggle with it, but there is a privacy dimension to it as well. So anyway.
Yeah, I think that's a very real and very important limitation of the right to an explanation that probably is riskier if including a process statute and could also exist if framed as the right to an explanation in another statute, where perhaps those making decisions can think, oh, that's fine. I explained how the algorithm worked. I explained where the data came from. So I satisfied the right to an explanation. Where I think the rationale behind having a right to an explanation is letting people understand how decisions about them were made, which involves a bit of a fuller explanation. And it also sometimes involves, I think, an explanation beyond explaining what the technical system does. Because one could have a technical system for a decision that's completely opaque, and then someone files the right to an explanation, and then one gives a very detailed explanation of the technical system, but that might still not be a complete explanation about why that decision was arrived at in partially automated processes.
Yeah, I think that's right. And it's only getting more complicated as the technology evolves.
Right. Yeah.
Yeah. So here's a question in case someone from your publisher is listening, and I think that may be the case. If your publisher told you you could have another 100 pages for your case, what areas would you add to or expand?
Well, I did think about this a lot, so this is an easy one. Although the publisher, again, has been so kind to me that if I had asked, probably they would have said yes, but we also needed to limit how many pages we make poor law students read and instructors assign. But if I got to add another 100 pages, I think what I would like to do would be to further enhance the comparative component. Because the casebook touches comparatively on the US and the EU, because those are the two legal systems that influence Canadian privacy law the most. But there could also be lots of productive comparisons, not in terms of what has influenced Canadian law, but what examples Canadian law could draw from for reform. And this could come from Brazil, from South Africa, from regimes in Southeast Asia that have had different approaches to regulating privacy that could be quite interesting and could be compatibilized with the Canadian system. So I think I would draw I would draw out more comparisons with the global South for the most part.
Interesting. All right. So I see there have been a couple of questions that have appeared in the Q&A. So I'm going to turn to one of those now, just to get our audience a bit more engaged. And here's a first question, which is, what do you think needs to change in the Canadian privacy landscape with regards to AI being trained on massive amounts of data, an increasing amount of which is personal information?
I think the main thing we need to change is the key mechanisms for protection that we give individuals. Right now, I don't want to simplify, and PIPEDA has lots of moving parts, but PIPEDA puts a lot of weight on one particular thing, which is whether people agreed or did not agree to a particular kind of information collection and a particular kind of information processing. And that can be helpful in a number of ways, but that is most helpful when one individual is processing information about another one, and those two people understand the extent of the processing and the extent of the consequences. And it is least helpful when a company is using AI to process information about someone. So in which cases do one consent to have the most weight? For example, non-consensual distribution of intimate images is one scenario where I think consent should have the most weight. People should have a say about what is done with pictures and videos of their bodies, where do they go, where do they not go, because they understand what the content is and they understand the consequences. But when we say, oh, we have all these AI companies scraping data, before making your data public, think really carefully about whether you want it scraped by an AI company and done things that you could have never predicted. It's your choice. Go ahead. That's not that helpful. So I think reinforcing principles that are already in PIPEDA, like data minimization and data protection by design or privacy by design, is much more helpful than reinforcing consent provisions for generative AI. And that is something that we can do to some extent with the current text of PIPEDA by focusing courts and enforcers towards those principles. But it's something that we can do much better when we do efforts for reform. And instead of putting political pressure on, oh, let's change consent from implicit to explicit, which will just lead to a flurry of notifications and requests, put political pressure on, oh, let's have some more substantive content for the principles of privacy by design and data minimization.
Okay, thank you. So I'm going to return to the questions in the Q&A in a minute. I see there's one in there about OpenAI, and maybe we'll have some time to discuss OpenAI in a bit. But I would encourage audience members, if you have questions, please post them in the Q&A. Ignacio, you have moved from McGill to Oxford, and one of the questions I have for you is, how has being in the UK given you any different insights on Canadian privacy law and or on Canadian privacy law reform?
I think so, yes. I think the main thing that being in the UK has showed me, particularly when I compare the UK with different EU countries and see what different EU countries and the UK do with very similar statutory text. For context, the UK has something called the UK GDPR. The UK GDPR is basically a copy-paste of the EU GDPR that the UK incorporated on Brexit. And so the UK follows the GDPR. Now it took out one article, which is Article 22, on the right not to be subjected to an automated decision. But other than that, the text is identical. And it's interesting to see what the UK regulator does with that text versus what the Irish regulator does with the GDPR versus what the French, Spanish, and German regulators do with the GDPR. Even if the GDPR is a text written in a way that is much more specific than PIPEDA. So I think the main thing that being in the UK and in closer conversation with the EU showed me is the enormous range of possibilities that the same text for privacy law gives regulators, and the different directions that a regulator can take. We spend a lot of time thinking about law reform as lawyers and as professors. And I think that is probably the most productive direction for Canada to take right now. But there are also enormous opportunities within a certain text for regulators and for courts to take. And perhaps my time in the UK and seeing what these different regulators do with this text encouraged me about what Canadian judges and enforcement authorities could do with the text that they have.
All right. Well, that's a whole other very interesting area to pursue. I'm wondering what your thoughts are, and you've talked a little bit about this already, but overall, what your thoughts are on the state of privacy law in Canada.
So I think it's interesting because Canadian privacy law is extremely sophisticated in the way that privacy law scholars and privacy lawyers think about it, while, as we've been discussing, being extremely outdated in its federal legislative framework, with provincial frameworks being better. And these two things coexist at the same time, leading to some asymmetries in how mature privacy law is in different spots. So on the one hand, you have Canadian courts that have developed a rich body of law on reasonable expectations of privacy and on Section 8, and on the crimes of voyeurism and non-consensual distribution of intimate images. And one can disagree with particular cases that courts have decided on Section 8, but one cannot deny that courts have thought about them very carefully. They have said that privacy has quasi-constitutional value, for example, in a way that is helpful. And the Privacy Commissioner's Office, for many years, have done very serious interpretive work with relatively limited tools and has done very interesting work with those very limited tools. And so the constitutional dimensions, the interpreted dimensions, and then to some extent the common law dimensions are in reasonably good shape. But then on the legislative side, as we've discussed, PPI is over 20 years old, hasn't been substantially updated, and many of the reform proposals that PIPEDA has seen double down on the aspects that make it outdated. And so the legislative prospect doesn't look very positive for the moment. People are now having obtained adequacy status under the GDPR, make me less optimistic about reform than I was when people had adequacy status for the 1995 directive, but not for the GDPR until a couple of years ago. And so it's this duality, I think, with very sophisticated people working in a very interesting way to a large extent with a statute that is not even clear about what's a suggestion and what's a right, and has a completely outdated apparatus that makes for all this interesting jurisprudence.
Mm-hmm. And I was going to ask you what you think are the most important issues for law reform, whether public and private sector. It sounds from our discussion so far that consent is going to be high, or addressing consent is going to be high on the list. But I'll let you answer that. There may be other ones that you want to flag as well.
Yeah, I think that I can think of lots of them, but if you make me pick two, I would think the main two ones are rethinking how much weight we put in individual consent and the weight that we put on individuals to self-protect from the universe of privacy harms that can happen to them in unpredictable ways, and enforcement architecture, rethinking both how difficult or easy we make it for people to file class actions, and rethinking the extent to which we don't give the investigative authority enforcement powers. I think just those two things would absolutely transform the effectiveness of Canadian privacy law without creating increased regulatory costs. And then there are others that could go around them.
Yeah. All right. And I see that there are more and more questions appearing in the chat, which is great. I appreciate that. Let's maybe shift and talk a little bit about OpenAI. Now, I realize the decision just came down last week, and given how long it took to reach that set of findings, we should all have like several years to read and think about them. But so sorry to put you a little bit on the spot, but we do have a question from the audience. Which is that, do you think Canadians could bring a privacy class action against OpenAI given recent findings by the OPC and its provincial counterparts? What would be needed practically to advance such a case? So that combines a couple of things, right?
Yeah.
Including your interest in privacy class actions.
Yeah. So I should start with a qualifier that I'm not legally allowed to give any legal advice in Canada or anywhere in the world at the moment, but particularly in Canada, not physically being there and not being barred. However, in terms of legal information that I can provide, it's not an easy question to answer, particularly because of the findings, if I understood them correctly, of what the four regulators ended up arriving at. So the substantive findings of the collectors was, as one would expect, that OpenAI's initial data collection was overbroad, that consent was insufficient, that transparency obligations were not met, and that accuracy safeguards were somewhat inadequate. But I think at least what I found most interesting in that report is what the slightly divergent outcomes from the different regulators show about Canadian regulatory architecture. So the federal commissioner found one thing about PIPEDA that largely solved the issue. The Quebec Commission found something slightly different. The British Columbia and Alberta commissioners found it unresolved because implied consent and explicit consent are different in the provincial statutes than in the federal statute. So you see the same conduct, the same company, and different conclusions from bodies of law that are considered substantively similar, even on something that affects all Canadians in a meaningful way. And while that sounds anecdotal, I think that is significant for identifying how common these statutes actually are, and it does affect the extent to which people can bring class actions. The main challenge for bringing a privacy class action usually is showing commonality, and depending on the province that one is in, that requirement looks quite different. In some provinces, the common element has to predominate, while in other provinces, the common element doesn't need to predominate. So we see more class actions in some provinces than in others. And the extent to which the common harm might predominate in something like a massive class action against OpenAI versus what the individual variations may look like might be different in one procedural system than another. That's one hurdle that class action might have. Another hurdle that the class action may have is showing a particular form of harm that leads to compensation that is different from the statutory non-compliance. So usually, and this has lots of qualifiers, but usually statutory non-compliance that doesn't lead to an individual group harm would be resolved by the regulator by sanctioning a company for non-compliance with the statute. And I'm sorry that the sun is poorly on my face and it's reflected on my glasses right now. And then class actions would follow or would run in parallel if and when the statutory non-compliance produces harm on a group. And a challenge in this case will be to show not only that Canadians didn't like that OpenAI breached PIPEDA in this way, but that Canadians were harmed in a particular way that would determine by the class action if Canadians' information was processed in this particular way. And Canadian courts have been somewhat reticent at recognizing loss of privacy in itself as a harm. So one would need to make a pretty good argument about loss of privacy in itself being the harm for a large class action to work, or one would have to find some other harm that a large chunk of people shared to file a class action that way. So I'm sorry to not have a very easy, straightforward answer as to yes, it would be a class action, or no, it would not be a class action. But I think it does depend on the way that it's argued, on how the class is framed, on the province where it's filed, and on other adjacent things to those.
Yeah, and that's a classic lawyer's answer, right? It depends.
I guess, yeah.
So
the classic law professor answer would have been, I don't know, what do you think? But I
well, there's that too, yeah. So to just dig a little deeper on the OpenAI findings, and I was struck by something that you mentioned early on, which is this lack of. I think the decision does reveal kind of a breaking down of the substantial similarity between the privacy legislation, and I think for a number of years now, the commissioners that have private sector jurisdiction have been doing more joint investigations of large corporations that operate across Canada. And those joint investigations have, for the most part, highlighted kind of normative similarities across the different statutes and similarities in approaches. And, you know, you can, and it's certainly, you can make the argument that this is beneficial and helps organizations understand the threshold for compliance across all of these different statutes, which may help to make the Canadian context a little less chaotic. But that breaks down in the OpenAI decision. It's chaotic. What do you think this is? I mean, is this just because of the particular questions that were raised, or is this really signaling that we've got some fundamental issues that we are going to need to take care of, possibly through, you know, privacy law reform processes at the federal level and provincial levels as well. But, is this an aberration, or is this just a wake-up call?
Can I say both?
Okay.
I think both. So first of all, I do think that it's wonderful that Canadian regulators do this form of joint investigations. It does two things. First of all, it can highlight very helpful commonalities between the different statutes. Second, it avoids duplication of the cost of investigation when they work together. They don't have to in parallel investigate all these other things. And third, when we have a federal enforcer that doesn't have enforcement powers, it helps put more pressure because it shows that it's more significant. I wish EU regulators did joint investigations like this more often. The reason for which I said both is that I do think that provincial statutes and the federal statute have a lot in common. They're framed in similar ways. They're both framed, well, the federal statute was modeled after the 1995 directive of the EU. The provincial statutes are mostly modeled after the GDPR, and the GDPR is modeled after the 1995 directive. So they follow generally a similar approach. They have similar structures, and the idea that they're compatible is well founded. However, they do have substantive differences, and most of the substantive differences are born out of the fact that the provincial statutes are better. They're newer and they're better, and so to some extent, it can be considered somewhat of an anomaly because I don't think this would be the result of every investigation. I think lots of other investigations can reasonably lead to a convergence between the statutes. On the other hand, it's not so much of an anomaly because it is not surprising that an outdated statute and updated statutes diverge at one technology that is one of the newer ones. It is understandable that the older statute is not as good at addressing a new technology as the newer statutes. And so to the extent that the privacy problems that we will continue to see in the next years will be to a large extent about AI and about generative AI, this anomaly might turn less anomalous.
Mm-hmm. Yeah. No. So, and if we're still dealing with an outdated statute in several years, as the technology evolves, we'll get to see the results of that.
Yeah.
So I'm going to turn again to a question from the Q&A from the audience. And this is certainly something that you talk about, that you address in the casebook. And the question is, can you talk about the development of information fiduciary torts in Canada and how these interface with PIPEDA? My understanding is that they are not mutually exclusive.
Yeah, they're not mutually exclusive. They're not only not mutually exclusive, but I think they're complementary in lots of helpful ways. So first of all, first, the harm idea that we see in the torts context could be very helpful to think about PIPEDA in general. When we think about PIPEDA actions, we could go to tort law to try to see what is harmful for a private action in the context of PIPEDA. But second, an action can be brought that involves PIPEDA and tort law at the same time. One could say that something is a breach of a provincial tort law and a breach of PIPEDA, and that could help the compensation mechanism meaningfully. And the other thing that the question mentions, information fiduciaries, I think is quite important because information fiduciaries is not, at least yet, part of Canadian law. It's mostly a reform proposal that a group of people think would be very productive, in that it would be productive for the statute to say that those entities that process information need to have the best interest in mind of those whose information they process. Now, that would be a significant reform of Canadian law that would be quite interesting. But tort law gives us a middle space between what information fiduciaries would give us and what PIPEDA does give us. If we infuse PIPEDA with more tort law, with more protecting people's reasonable expectations of privacy, with more non-material understanding of harm, then without having a reform as massive as information fiduciaries, then we would be going around lots of the limitations that PIPEDA has. And I think that could be an interesting avenue to explore to, in the next round of attempted reform of PIPEDA, examine to what extent are information fiduciaries helpful and to what extent are they feasible? And also to what extent is it helpful and feasible to protect people's reasonable expectations, even when a company doesn't keep their best interest in mind, just when it keeps their reasonable expectations in mind. And we could examine how that leads to different forms of revised federal statutes.
Yeah, it's certainly interesting to think about how we might, because these are really interesting ideas and ones that I think are well adapted to the changing information economy, but interesting to think about whether and how we address them in statute law or tort law. So we have another question which circles us back to comparative analysis. And the question is, what is an example where a global South country has approached privacy law in a way that Canada can learn from? Is there a specific example you can expand on, and why does it stand out?
Yeah, I think my favorite example would be from a global South country would be Brazil. Brazil has a statute that is quite modern, that's modeled after the GDPR. Brazil relies on individual consent a little less than most other jurisdictions. Now, all jurisdictions that are modeled after the GDPR, for some reason, rely on consent more than the GDPR, because the GDPR has 6 bases for processing, and most of these other jurisdictions have only 1 basis for processing, which is consent, like PIPEDA does. But Brazil does something very interesting, which is besides having an enforcer with actual enforcement powers, Brazil has a private rights of action system that recognizes non-material harm, like the GDPR does, for redress. So imagine the following situation. Imagine someone running an LLM that scrapes data from everyone in a country. This is entirely hypothetical, in ways that do not fit how those people expected their information to be processed. Imagine that maker of an LLM creates an LLM that is manipulative, and it keeps people hooked with lots of dark patterns and other addictive design decisions to keep people on the LLM at all times, looking at the ads that person or that entity shows in the chat. It would be difficult in most countries to bring private redress for that, because one would have to show some sort of material consequence and material harm for it. One would have to show, oh, this person had their gambling addiction worsened. Oh, this other person spent less time with their family and their partner left them. This other person had this different problem because of the addiction. Those things, while real, are very difficult to aggregate in a class action because the consequences are all different. But when you have a system like the GDPR or like Brazil that recognizes non-material harm, then the fact of designing something to make people addicted to it is already a non-material harm that is common to all of them. So while it might seem small, it's a huge difference on the extent that it allows people to get redress and the extent to which it disciplines companies. If I had to pick one, I think it would be that one.
That's an interesting example, and certainly Canadian courts have not been. I mean, even if we recognize non-material harm, in the legislation, and there's an avenue for class action, we've seen that Canadian courts are a little bit shy when it comes to non-material harm. And I get a vibe, and maybe this vibe is a misinterpretation, but my vibe is that Canadian courts are trying to narrow the bases for privacy class action lawsuits, and to try and limit the scope and extent of privacy class action lawsuits. And one of the pressure points is this non-material harm. And so I welcome your thoughts on whether I'm right about that or not. But do you think that there's just kind of a reluctance in Canada to recognize non-material harm as a basis for privacy class actions, out of a concern that this is just going to blow the privacy tort universe apart?
I think there's a concern in Canadian courts that I also see in courts abroad that is reasonable. And the concern is, if we say that any breach of PIPEDA is harmful, then lots of things are breaches of PIPEDA, and then we would have an opening of the floodgates to privacy class actions. And then how would we control that? And then how do we keep the separation between public and private enforcement if any breach of the statute is considered harmful? I understand where that comes from. But the problem is that when we think about class actions, we end up discussing corner solutions. The corner solutions are either any breach of the statute is considered harmful and automatically gives the right to sue and to compensation, or none of them are, unless one has a very specific tangible consequence. And neither of those corner solutions are desirable. And I think that's one of the situations where seeing privacy law as a whole that crosses tort law, statutory law, and Section 8 can be helpful, because tort law and criminal law give us a very clear sense of one type of harm that is protected by the law already, which is privacy harm. When in Jones v. Singe, Singe looked over Jones' financial documents repeatedly, and the Ontario court said, this is something that is protected under tort law because we don't want to live in a society where one person can do this. And it gave a couple of $1,000 as remedy for that intrusion. What the court was saying is that there was a harm to privacy there that was separate from whether Jones also suffered financial harm or discrimination harm or reputational harm. But then sometimes when courts are dealing with statutory law, they forget about that, because they sometimes mistakenly see statutory privacy law as bracketed away from privacy tort law, because the two fields of law are not presented together often enough. And that's a problem. A potential middle between saying everything can be a privacy class action if it's a statutory violation, and saying, almost nothing can be a privacy class action because we don't see common material consequences, is saying things can be a class action if people suffer the same privacy harm. And in many situations they have. That avoids the problem of opening the floodgates, and that does generate more accountability than the situation that we have right now. While I do share your vibe check that courts are quite worried about this and are not expanding in class actions the use of harms, I do see them recognizing different forms of harms in individual actions. And I see no conceptual reason to say that harms that court recognize in individual actions disappear when we aggregate those individual actions. So I think when we see privacy law comprehensively, there are very useful avenues to persuade courts that their reaction when they see this avalanche of class actions is not to say no to all of them, but to develop ways to discern which ones are meritorious and which ones are less meritorious.
All right. Well, thank you. It's certainly lots of interesting stuff to think about in that. I'm going to turn back to the questions because they continue to roll in.
Oh yeah.
And so what concerns you the most about where privacy rights are heading, and how hopeful are you that updating privacy laws will address these concerns?
I want to give a positive answer, but it's difficult. So wait, the first half was what makes me optimistic, and the second is
what concerns you the most about where privacy rights are heading, and how hopeful are you that updating privacy laws will address these concerns?
okay. What concerns me the most is that in different reform efforts that I've seen, not only Canada, but also in other jurisdictions, I don't see any less pressure put on individual consent. I see a move from implicit consent to explicit consent requirements. I see a more robust set of individual rights of data control, like the right to be forgotten, the right to data portability. But I don't see more substance necessarily in what is most helpful, which is the principles that can generate accountability at scale, such as privacy by design and data minimization. That worries me because we can have a very modern statute that is very strict, but as long as most of the weight of protection is put on the shoulders of individuals to be able to anticipate what data processing is harmful to them and what data processing is not harmful to them, to consent explicitly or not consent explicitly to them. And then we give them a bunch of rights of data control where they need to know where and how and when they exercise the right to be forgotten. And they need to know where and how and when to exercise the right to access. That can be very useful in a number of situations, but is not very useful in most of the things that are producing harm in the information economy, and certainly not very useful in most of the cases that involve AI. So that's my main concern. And the main thing that I find hopeful is that in many newer statutes, including many of the ones that have been proposed in Canada, I do see a more robust enforcement architecture and a better division of labor between public enforcement and privacy class actions that I think is good both to reduce the administrative costs that enforcers have because they cannot investigate everything as privacy law continues to grow and as more aspects of our social and economic interactions are mediated by our personal information and can bring better and more precise accountability.
All right, thank you. Another question is, are there any privacy law decisions that you think courts got wrong or where the outcome created unintended consequences, whether for individual rights, innovation, or operational realities for organizations?
Let me think of privacy law decisions. Let me give you a category of privacy law decisions instead of one particular privacy law decision to not go after any individual court that might be doing their best effort at applying the law and protecting people. So I think one category problem that we often see in courts that mean well, including the Canadian Supreme Court, is picking at particular privacy policies and deciding that one particular clause in a privacy policy was insufficient under the doctrine of unconscionability because people couldn't possibly understand or consent to that one particular clause in a privacy policy, which is often done, for example, with arbitration clauses, where people are told, oh, if you disagree with this, you cannot seek redress. You have to go and seek arbitration in this other country where it's very difficult or impossible for you to do that. I think that is to some extent desirable because it is helpful to say, yes, a company cannot just put an arbitration clause and cut off any sort of private enforcement of their violations of Canadian law by the people who sign their privacy policies. But the unintended consequence of that good faith effort and that desirable decision is that it makes it seem like every other clause in that privacy policy is actually well understood by the person, that consent is valid, and that it is not unconscionable. when the reality is that privacy policies, even if we have the time, the attention, and the expertise to read them very carefully, don't tell us very much about what happens with their personal information. Privacy policies are geared towards explaining technically how information is collected, processed, and disclosed, but they're not geared to tell us what risks happen and what risks exist based on our personal information. And the whole idea of individual consent is that people can determine those risks. So, for example, a privacy policy might say something like, we will share information with third parties. But I don't know, even as someone who dedicates their life to privacy law, whether that means we have small servers, so we will put your information in an external server that we contract with that has the higher cybersecurity standards, and your information will be very safe there. Or whether that means actually we sell what you tell us and what we guess about you based on what you tell us to third parties that may then price discriminate against you, that might exploit your vulnerabilities, and that might manipulate you. And those two things are very different. But the ways that privacy policies are written in a way that is compliant with Canadian law means that even an expert with lots of time to read them cannot distinguish them. I think that means that we cannot say that any individual clause in a privacy policy is unconscionable and the rest is perfectly valid. I think that means that we need to change how we inform people about how their personal information is processed.
So you've talked about how, in fact, you've been critical of how the law doubles down on consent and how law reform seems to be continuing to sort of say consent is at the heart of the legislation. And now you've been critical of courts that have enabled this consent framework by finding only specific parts of a policy to be problematic. So do you think courts should be playing a bigger role in debunking the myth of consent in the privacy context?
They could. I mean, it could be radical, but I think they could, and we certainly have the legal principles for that to be there. I mean, the things that even if PIPEDA move to a system of explicit consent, where only people that actively say that they agree have consented to a privacy policy, to a cookie notice, or to any other kind of information collecting and processing. The reality that we live now with the processing of people's data with AI that produces inference about them that are impossible to anticipate. Just anecdotally, for example, everyone who's joining this call can have their political preferences inferred from things as inoffensive as their coffee orders, their ethnicity inferred from things like what music they listen to. And those are just inferences from one information point. I cannot even begin to outline the countless number of inferences that are possible when we aggregate different information points that seem unrelated to the inference that happened. In that context, I don't think it's far-fetched for a court to say we have principles about what consent means in law. Consent in contract law and elsewhere is based on some sort of understanding of the object of what you're consenting to. So when you're consenting to a particular data practice, you need to have a sufficient understanding of what that data practice is to consent to that object. Therefore, most consents under privacy policies are invalid. I think that's a consequence of contract law and consumer law. Now, is it a significant change of how we think about privacy law? Yes, but it's not a significant change from how courts normally think of consent in other contexts.
Yeah, and that's certainly the case. Yeah. Okay. I see we have another question in the Q&A that follows up on a discussion we had earlier on fiduciary torts. And so the question is it possible that part of the difference with information fiduciary torts is linked to data protection, the data protection focus of EU or UK law? And how different is that from PIPEDA and provincial and territorial private sector focus? Are those distinct branches of analysis?
Yeah, so one caveat, and then I would separate between three things. The main caveat, or I guess the main clarification, is that I don't think different aspects of Canadian law should work under different modes of analysis. I think the most helpful thing to do with Canadian privacy law right now is to unify what are right now siloed modes of analysis, which are not siloed modes of analysis by design, they're siloed modes of analysis by accident. And linking them and showing where they talk to each other can be productive for lawyers, for judges, for enforcers, and for students. Now, that said, I would do three separations, not on the ways that we should think about it, but on the mechanisms to achieve the same type of thought. To identify the difference and commonalities. So one of them is privacy torts. And different provinces have different privacy torts. Quebec has Articles 36 and 37 of the Civil Code, and provinces either have one tort of privacy or a tort of intrusion and then a tort for disclosure. So one tort for collecting the information and one tort for sharing the information. And that, interestingly, mirrors criminal law, where there's one crime for voyeurism, which is acquiring a certain type of information in inappropriate ways, and one crime for non-consensual distribution of intimate images, which is sharing that type of information in inappropriate ways. Then, after that mirroring, we have perhaps what is the closest mirroring, which is PIPEDA, the federal statute that mirrors data protection law in the EU. PIPEDA was written in the late 90s, modeled after the 1995 Data Protection Directive. Partly because it was a good idea, partly because the 1995 Data Protection Directive in the EU had one provision that said, if you want to trade data with the EU, you need to have a data protection system that the European Commission considers adequate for sharing information of EU citizens with you. And that led to a wave around the world of data protection reform that included Canada. So I think while there are underlying ideas in common across all of these, one close similarity I would put is between tort law, Section 8 law, and criminal law. Another close similarity, I think, is between PIPEDA and EU statutory law. And then separately from that, I would put information fiduciaries, which is a proposal that doesn't yet exist in law that takes tort law principles and takes principles from fiduciary law and puts them onto commercial relationships in ways that experts disagree about whether it's helpful or it's not helpful, and it leads to all sorts of interesting discussions. Now, fiduciary law could say lots of interesting things about both tort law and about statutory law. Statutory law could say lots of interesting things about fiduciary law and about tort law. And tort law can say all sorts of interesting things to statutory law and to fiduciary law.
All right. I mean, that's a great answer. And I appreciate your ability to respond on the fly to some, really complex and interesting questions.
Oh, they're good questions.
They are good questions. So I have a question that made me smile from flagged as being from a layperson, which I think is nonetheless a very astute question. And the question is quite simply, why is data brokering legal?
So why is data brokering legal? I don't think I have an answer to that one. I think it's a very good question. Well, let me give you my best faith answer. Instead of telling you what Ignacio thinks, let me give you the answer that I think a good faith data broker might have. Not a bad faith data broker, obviously there are plenty, but a good faith data broker. And I guess a good faith data broker might say something along the lines of, not all data aggregation is harmful, and some sort of data aggregation might be harmful, but other sorts of data aggregation might not be harmful, and therefore some sort of data aggregation should be allowed. Now, I think part of the problem is that if we take that argument from that hypothetical good faith data broker, is that the law doesn't currently distinguish between types of data brokering. The law doesn't currently distinguish between buying information from different people to assemble an accurate credit score to give to banks so that we give people loans when they deserve them and when they have capacity to repay them, from assembling lots of information about people to sell them to the highest bidder to exploit their vulnerabilities. And that is because we put too much of the pressure of privacy law at the moment of collection and not enough pressure at the moment of processing, distinguishing legitimate uses from illegitimate uses, distinguishing good faith uses from bad faith uses, distinguishing uses that involve deliberate exploitation from uses that involve facilitating accurate decision making. And part of why a lot of data brokering is so nasty is because the law doesn't make those distinctions.
Yeah, and I think that's a great observation. So we are getting very close to our time limit here. I'm going to give you one last quick question before we wrap up. Canada's been thinking a lot lately about its place in the physical as well as digital world. And as you know, Canada's Privacy Commissioner currently leads the Global Privacy Assembly. What are your thoughts on Canada's place or role internationally when it comes to privacy?
I think I see a lot of international credibility that Canada has in privacy law. And I think that's partly thanks to incredible experts that Canada has in academia, in the regulatory spaces, and in law firm. They're very thoughtful about privacy law, are very thoughtful about reform, and are very thoughtful about application. And the commissioner selection in the Global Privacy Assembly puts this kind of together because it puts Canada in this leadership position. That's an opportunity for Canada to continue cementing its leadership in privacy law. It's an opportunity for Canada to take this leadership position to improve its legislative frameworks to match this international reputation. And it can also be a risk if Canada uses this opportunity to say, we're a leader in privacy, we don't need to change anything. And I hope this leans on the side of opportunity and not on the side of risk.
Yeah, as do I. Well, let me thank you. I really enjoyed this conversation, Ignacio. It's been terrific. And thank you also to our audience for their engagement and their questions. I see Florian wants to come on, and I will give him the last word as well. But thank you so much for joining us today, and congratulations on your new book.
Thank you very much. Thanks.
Yeah, thank you so much to both of you. And yeah, I wanted to jump at so many times during the conversation, but I think it's great at least I have the opportunity to close. And thank you so much for your last comment and call to action. And do we have a misalignment between our reputation and our actual legal frameworks? Surprise, surprise. So no, great call to action to everybody in the audience, for people at the federal government. I hope they will listen to you. I mean, you made this call to action a few times before. Teresa, and myself too. So let's hope that, maybe
all three of
this
us.
year is the year they will listen, but one can only hope. So again, thank you to both of you for this amazing, lively conversation, and for the audience that was with us and with all the great questions we had. I think we were able to answer most of them, not all of them. So that's maybe also another call to action to have another event, maybe this time in person with you in Ottawa. But thank you.
That'd be really nice.
Yeah, that would be lovely. Thank you so much for everybody to be in attendance with us. And perfect. Have a lovely rest of your day. Bye-bye.
Thank you so much, Teresa. And thank you so much, Florian. See you, everyone. Thank you.